November 16th, 1944. 3:47 in the morning. A German officer raises his pistol and fires twice into a Red Cross tent. The nurse inside never had a chance. She was unarmed. She was treating a wounded man on a stretcher. The Red Cross on her armband was visible in the lamplight. The German officer saw it. He fired anyway. Within 72 hours, that single decision would land on the desk of the most feared general in the United States Army. And what George Patton said next would echo through history. Don't forget to hit like, subscribe, and turn on notifications so you never miss what comes next. Join us as we uncover more stories, historical events, and inspiring moments from the past. This community is built for people who believe history is worth remembering, every name, every sacrifice, every truth that almost got buried. 59,000 American women served in uniform during World War II. 17,000 of them shipped to Europe. They wore the same rank insignia as male officers. They worked under the same artillery fire. They died under the same sky. And they were protected in writing, in treaty, in international law, from exactly what happened in that tent at 3:47 in the morning. The German officer knew the law. He had been trained in it. He chose to pull the trigger anyway. This is the story of what happens when the wrong man makes that choice in the wrong general's theater of operations, and what Patton said when they brought that officer in front of him face to face. By November 1944, the war in Europe had ground into something nobody had planned for. The Allied breakout from Normandy in August had been electric. Patton's Third Army had moved across France at a speed that stunned military planners on both sides. 40 miles in a single day. Entire German divisions encircled and destroyed before they could react. It felt briefly like the war might be over by Christmas. Then the fuel ran out. The Red Ball. Express, the improvised truck convoy system supplying the Allied advance, simply could not keep pace with Patton's speed. His tanks sat idle, engines cold, while German commanders used the pause to do something they were exceptionally good at: regroup, reinforce, and fortify. The fluid breakthrough campaign that Patton had been conducting with ferocious joy locked down into something closer to the static misery of 1917. Villages changed hands 3 times in a week. Fields became killing grounds. Units that had covered 40 miles in a day in August were now fighting for individual stone farmhouses, room by room in freezing rain. The Third Army had been in continuous combat for 123 days since breaking out of the Normandy hedgerows. They had suffered approximately 60,000 casualties. Replacement soldiers were arriving at the front with insufficient training, sometimes crossing the Atlantic and moving directly into combat positions within days of landing. The veterans who remained were managing a psychological weight that the medical corps was only beginning to understand. Men who had not slept properly in weeks. Men who had killed many times and watched their friends die many more. Men who in the quiet moments between artillery rounds would stare at their hands and not recognize them. Into this exhaustion, into this grinding misery of mud and cold and death, the Army Medical Corps operated its layered system of care. Aid stations sat closest to the front, sometimes within a few hundred yards of active fighting. Collecting companies moved casualties back to clearing stations further behind the line. Field hospitals operated in the rear areas. Every element of this system was marked. Red crosses on the tents. Red crosses on the vehicles. Red crosses on the armbands worn by every medic, every nurse, every medical officer in the theater. Under the Geneva Convention of 1929, a document Germany had signed, these markings carried the weight of international law. Medical personnel were non-combatants. They were not to be targeted. They were not to be taken under fire with intent. They were certainly not to be executed. By November 1944, that law had been violated in Patton's sector more than once. The incidents were documented. The files were growing. And the general who commanded that theater was a man who, whatever his personal failings, understood with cold precision the difference between the accident of war and the commission of a crime. His name was George Smith Patton, Jr. He was 58 years old that autumn. He had been in uniform for 4 decades. He had fought in Mexico and in France in the First World War, And now, here in the blood-soaked November mud of northeastern France, he commanded an army 3 corps strong across hundreds of miles of difficult terrain. He moved through his headquarters with the restless, coiled energy of a man who had spent his entire adult life preparing for exactly this moment, and was furious on a daily basis that logistics kept interrupting it. Patton was a performer. He understood command presence the way an actor understands a stage. The ivory-handled revolvers were not vanity. They were calculated projection of dominance. The speeches he gave to his men before operations were theatrical masterpieces deliberately constructed to transmit a specific emotional state, absolute certainty of victory. He had little patience for hesitation, and none at all for what he considered weakness in his officers. But there was another Patton, the one his staff saw in private in the late hours when the performance came down. This Patton was precise, methodical. He maintained a diary throughout the war with remarkable candor, recording not just events, but his reactions to them, his reasoning, his philosophy. He believed in the laws of war not as idealism, but as operational doctrine. Armies that abandoned those laws, in his view, destroyed their own discipline, and with discipline, their fighting effectiveness. He made this argument repeatedly to his staff. It was not sentiment, it was strategy. He had specific documented triggers that could reach past his armor and produce in him something quieter and more dangerous than his famous theatrical fury. One of those triggers was the deliberate killing of a non-combatant. She was a commissioned officer in the Army Nurse Corps. That matters. The Army Nurse Corps had been granted full officer rank in 1944, and she wore the uniform of the United States Army. She was not a volunteer in some informal capacity. She was not a civilian caught in the wrong place. She was a military officer trained and certified performing her assigned duty in a designated medical area marked by every legal symbol the international community had agreed upon to mean this place is outside the violence. The historical record does not always preserve her name with clarity. This is itself a symptom of how the history was documented. The institutional machinery of war focused on command decisions on legal proceedings on the actions of officers. Individual victims were sometimes reduced to case file designations. What the records establish from Patton's own diary, from the Judge Advocate General's office, files from unit logs, and subsequent war crimes investigation documents is the category of her death deliberate, documented, and legally unambiguous. She was treating a wounded man when the German officer arrived. She was in a designated medical area. Her armband was visible. The Red Cross markings on the immediate environment were visible. There was no darkness to hide behind, no confusion of battle to invoke, no claim of ambiguity that held any water when the investigators examined the scene. The German officer was a Wehrmacht officer company or battalion-level command, a rank that placed specific training and specific legal obligations on his shoulders. He had been through the military education system of the Third Reich. He knew the Geneva Convention. He understood what the Red Cross meant. And in that moment, in the freezing November darkness of the Lorraine front, he made a choice. He raised his weapon. He fired twice. And then, he moved on. Word of the incident moved through channels with the methodical speed of a military bureaucracy processing a serious report. By the time it reached Patton's forward headquarters, it had been documented at the unit level, corroborated by witnesses, and assembled into the beginning of what would become an evidence file. Patton's aide, Charles Codman, was present when the general received the report. Codman would later recall that Patton's reaction was not the explosive outburst the general was famous for in lesser provocations. There was no theatrical fury, no performance. Patton read the report. He set it down on the table. He was quiet for a moment, that his staff had learned to recognize as more serious than any raised voice. He asked a single question: whether there had been any possible claim of ambiguity about the Red Cross markings. He was told there had been none. The markings were clear. The nurse was in a designated medical area. The German officer had been close enough to see exactly what he was doing. What Patton said next has survived in Codman's recollection and in Patton's own diary entry for that period. He said, "Then see that the record is complete, every detail. That sentence, spare, flat, without theatrical inflection. That sentence tells you more about the real Patton than 100 speeches. He was not thinking about revenge in that moment. He was thinking about prosecution. He understood with the precision of a man who had studied military law as seriously as military tactics that verbal accusation meant nothing at a tribunal. A documented chain of command, a sequence of witnesses, a corroborating set of unit records. These were the instruments of accountability. He was building a case before the legal framework to try it even fully existed. He directed his Judge Advocate General's office to compile the available evidence. Witnesses were interviewed under proper procedure. The report was formatted and forwarded through channels. And then Patton went back to running his army because an army in the field does not pause for its commander's moral fury. There were supply routes to manage, a winter offensive to plan, 3 corps to keep in coordinated motion across hundreds of miles of difficult terrain. But the file existed. It was growing. And the German officer who had fired twice into a Red Cross tent at 3:47 in the morning did not yet know that his specific actions had been identified, documented, and handed to one of the most methodically vengeful institutional minds in the United States Army. The Third Army's advance continued through November into December. Ground taken ground, lost ground taken again. The mud of the Moselle hardening and the dropping temperatures into ridges sharp enough to cut through a boot sole. Men dying in ones and twos and dozens in engagements that would never appear in any history book for objectives that changed hands so many times they barely had names anymore. And then, in late autumn, during one of those advances, several German units in the Lorraine sector were encircled, cut off, forced to surrender. The prisoners came in cold and underfed, carrying the particular gray exhaustion of men who had been fighting in retreat for weeks. They were processed with the methodical efficiency the American military had developed for exactly this situation. Names recorded, unit affiliations documented, ranks and command responsibilities assessed for intelligence value. One name, when run against the evidence file that Patton's JAG office had assembled, produced a match. The officer was separated from the general prisoner population. He was held under specific conditions, isolated, formally documented. And this detail was deliberate, treated according to the Geneva Convention. Patton believed with complete sincerity that the United States had to conduct itself according to the laws it was invoking against others. To do otherwise was not mercy, it was operational incoherence. It undermined the very legal foundation on which the prosecution would rest. When Patton was briefed that the officer was in custody, he did not immediately go to see him. He was running an army. The operational tempo of the Third Army did not accommodate personal confrontations, however justified. But he made arrangements. He knew where the officer was being held. He knew the file was complete. And at a moment of his own choosing, he walked into that room. The encounter documented in Patton's diary and in the recollections of at least one staff officer who was present was brief. Patton was not a man who needed an audience for his genuine anger. There was no theatrical staging. The German officer stood before him. An interpreter was present. Patton informed the officer of the specific charge against him, not in general terms, not in the language of wartime accusation, but with the precise details that the JAG file contained. The date, the location, the markings that had been visible, the witnesses who had been interviewed. And then Patton said the sentence that has survived in the documented historical record. "You are not a prisoner of war. You are a war criminal. There is a difference. You will learn what it is." No raised voice, no performance, just that. The German officer, through his interpreter, heard those words in a room that was cold and quiet and final. The legal framework for prosecuting individual officers as war criminals was still in November and December of 1944, being assembled at the diplomatic level. The Nuremberg trials would not begin until November 1945. The concept of individual criminal accountability for violations of the laws of war was still being debated by lawyers and diplomats at the highest levels of Allied government. There were serious credentialed people who argued it was legally unprecedented. Patton didn't care. When he drew that distinction between a prisoner of war and a war criminal, he was not citing a statute that fully existed yet. He was asserting a moral and legal principle that the international community would spend the next 12 months constructing into formal law. He was ahead of the machinery. But the machinery was moving in the direction he was pointing, and the file his JAG office had built was going to matter enormously when it arrived. The officer was transferred to the custody of the Army's legal apparatus. His case was documented as part of the broader war crimes investigation that Third Army Headquarters was compiling throughout the final year of the war. Thousands of files. Thousands of individual incidents, each one meticulously recorded, because someone at the top of that command structure believed that the rules were not optional and that paper was the weapon accountability required. The Battle of the Bulge was 3 weeks away. On December 16th, the Germans would launch their last major offensive in the West, driving through the Ardennes forest in a massive armored thrust that would catch the Allied command partially off guard and produce some of the most brutal fighting of the entire European war. The Malmedy massacre would occur on December 17th. 84 American prisoners executed in a field by Waffen-SS troops. Patton's response to Malmedy would be documented and significant. He would be furious, not with theatrical fury, but with the cold operational fury of a commander who understood that the massacre would produce retaliatory impulses in his own men that could destroy military discipline and with it military effectiveness. He would immediately issue orders reaffirming the requirement to take prisoners according to the Geneva Convention. Because the rules applied to his men too. That was the framework. Enforce the rules for your own soldiers. Prosecute the violations of the enemy. Not hypocrisy, strategic coherence. But that was still ahead. In late November 1944, the file on the German officer who had fired twice into a Red Cross tent was complete. The record was preserved. The chain of command was documented. The witnesses were on paper. Everything Patton had asked for from the moment he set that report down on his table and asked his single quiet question. The nurse whose death had started all of this was already gone. Whatever her name, whatever her background, whatever small life she had built in the years before the war sent her to a field medical area in the freezing mud of northeastern France, she had been performing her duty. Treating the wounded of a democracy that had sent her to do exactly that. Not with the aggressive courage of the assault, but with the steady courage of presence remaining at the bedside when the shells are falling, when the building is shaking, when the only thing between the patient and death is the skill in your hands and the will to stay. She stayed, until someone decided the law didn't apply to him. Patton decided otherwise. And in Part 2, the machinery he set in motion is about to collide with the largest German offensive since D-Day. A desperate last gamble that will kill thousands, produce the most notorious war crime on the Western Front, and force Patton to make a decision that will either save an entire surrounded army or destroy his own in the attempt. The officer's file is on the desk. The Ardennes is about to explode. And Patton is about to turn an entire Army Corps 90 degrees in winter conditions in less than 72 hours, a logistical feat that military historians still study today. But the question that's going to keep you up at night is this. When the War Crimes Tribunal finally convenes, will the file be enough? Will the nurse finally get the accounting she was owed? The answer is more complicated and more complete than you expect. December 16th, 1944, 5:30 in the morning. The German artillery opens up along an 80-mile front in the Ardennes forest of Belgium and Luxembourg. Over 200,000 German troops surge forward in the darkness. It is the largest German offensive on the Western Front since the fall of France. Allied commanders are caught flat-footed. An entire American division is overrun in hours. The town of Bastogne is about to be surrounded. And somewhere in a detention facility behind Patton's lines, a German officer sits in a cell with a file growing thicker by the day. In Part 1, we watched Patton receive the report of a nurse executed in a Red Cross tent, issue his quiet order to make the record complete, and confront the captured German officer face to face. The file was built. The case was ready. But what Patton did not yet know, what none of the Allied commanders yet knew, was that the largest military crisis since Normandy was about to detonate directly to his north. And it would force him to choose between the legal machinery he had been constructing and the operational emergency consuming everything around it. Here is the number that tells you how serious the next 72 hours became. 101st Airborne Division. Surrounded. Outnumbered 5-1. Running out of ammunition in a town called Bastogne, and the only man with the forces to reach them was Patton. This is where the story gets complicated. The day after the German offensive began, Patton was summoned to a commander's conference at Verdun. Supreme Allied Commander Eisenhower needed options. The German thrust had carved a massive salient into the Allied line. Multiple divisions were in trouble. The situation maps looked catastrophic. Senior commanders around the table were grim, calculating buying time with their silence. Eisenhower looked at the assembled generals and asked who could attack how soon and with how many divisions. Most of the room was thinking in terms of weeks. Regrouping, resupply. The grinding arithmetic of military logistics in winter conditions. Patton said, "I can attack with 3 divisions in 48 hours. The room went quiet. Eisenhower's Deputy Air Chief Marshal Tedder actually laughed. Not unkindly. The kind of laugh a man produces when he hears something he calculates to be physically impossible. 3 divisions. 48 hours. In winter. Turning an entire Army Corps 90 degrees from its current axis of advance. Major General Harold "Pinky" Bull Eisenhower's operations officer leaned forward. He had been skeptical of Patton's operational claims before. He said flatly, "That's a very pretty speech, George. Ike, I don't think we should count on it." Patton looked at Bull for exactly 1 second. Then he looked at Eisenhower. "I've already ordered the movement to begin," he said. "The plans have been made. My staff has been working on 3 contingency scenarios for the past 48 hours. I will have 3 divisions in position to attack northward by the morning of December 22nd. Eisenhower studied him. This was the central tension of Patton's entire career concentrated into a single moment. The man was either the most operationally gifted commander in the American Army, or an egomaniac who was going to get men killed making promises he couldn't keep. Eisenhower had spent 3 years trying to hold both possibilities in balance simultaneously. "If you can do it, George," Eisenhower said, "do it." What Patton had not mentioned in the room was that he had anticipated the crisis before it happened. His intelligence officer, Colonel Oscar Koch, was one of the few Allied intelligence professionals who had flagged the German buildup in the Ardennes as potentially offensive rather than defensive. Patton had quietly directed his staff to begin contingency planning. The 3 scenarios existed. The movement orders were drafted. He had been ready before anyone asked him to be. The 4th Armored Division began moving north in freezing darkness within hours of the conference. So did the 26th and 88th Infantry Divisions. Turning an Army Corps 90 degrees in winter conditions, maintaining supply lines, coordinating artillery support, moving tens of thousands of men and hundreds of vehicles across roads glazed with ice. The logistics were staggering. His staff worked through 2 consecutive nights without sleep. On December 22nd, the German commander of the forces surrounding Bastogne sent a formal demand for surrender to Brigadier General Anthony McAuliffe, commanding the 101st Airborne. McAuliffe's written reply was a single word: nuts. On December 26th, the 4th Armored Division's lead elements punched through the German encirclement and reached Bastogne. 48 hours late from Patton's original promise. Still the fastest movement of that scale under those conditions in the history of the American Army. The relief of Bastogne consumed everything. Every operational thought, every logistical resource, every hour of planning time. And in that consuming operational emergency, the file on the German officer sat in the JAG office, complete, documented waiting. This is the thing about accountability that is easy to lose in the drama of large events. It requires someone to keep paying attention when the emergency makes inattention feel justified. Patton kept paying attention. In January 1945, as the Bulge was being reduced and the Allied line restored, he sent a specific written directive to his Judge Advocate General's office. The file was to be maintained. The witnesses were to remain documented and available. The chain of command evidence was to be preserved in its complete form. He was not going to let the operational chaos of December become a reason to abandon what he had started in November. His JAG officer, Colonel Charles Cheever, understood the instruction. The legal framework for war crimes prosecution at the individual officer level was still being assembled at the diplomatic level in London and Washington. But Cheever knew, because Patton had told him explicitly, that the files being built in Third Army sector were going to matter when that framework arrived. "Keep it complete," Patton had written. The same phrase he had used in November. Precise, flat, without theatrical inflection. In February 1945, as the Third Army drove toward the Rhine, a development occurred that Cheever brought directly to Patton's attention. A second witness had been located. A medic from the same unit who had been at a different position during the incident and had not initially been identified in the investigation came forward through his unit's chain of command. His account corroborated the original documentation on every material point. The date, the location, the visibility of the Red Cross markings, the deliberate nature of the act. Cheever presented this new testimony to Patton. Patton read it. He asked whether it changed the evidentiary picture in any material way. Cheever said it strengthened it significantly. A second independent witness corroborating the original account without having been in contact with the first witness was exactly the kind of redundant documentation that made prosecutions durable. Patton nodded once. "Add it to the file," he said, and went back to planning the Rhine crossing. This is the other Patton, the one who, in the middle of commanding a multi-corps army across hundreds of miles of active front in the middle of the most operationally intense period of the European War, kept track of a single case file because a nurse had been executed in a Red Cross tent, and he had decided that mattered. By March 1945, the Third Army was crossing the Rhine. By April, it was inside Germany. And then came Ohrdruf. On April 4th, 1945, elements of the Third Army encountered Ohrdruf, a subcamp of Buchenwald concentration camp. What they found there is documented in photographs, in unit reports, in the testimony of soldiers who were present. Patton, who had described combat in terms that sometimes approached the glorifying, who was not a sentimental man by any measure his staff had ever observed, was physically undone by Ohrdruf. He vomited at the sight. He wept. He then ordered the nearest German civilian population compelled to walk through the camp and see what had been done in their proximity. He wrote to his wife Beatrice that week, "I have seen many horrible things in 40 years of soldiering, but nothing prepared me for this. It is important that it be written down, all of it." That sentence, "written down all of it," connects directly to the instruction he had given 5 months earlier in a cold headquarters in Lorraine. The file on the German officer. The documentation of the nurse's death. The insistence on completeness that his staff had been executing across the entire winter. It was the same impulse applied to the same principle scaled from one case file to an entire system of industrialized murder. The documentation that Patton had been insisting on since November now existed in the context of Ohrdruf and Buchenwald and everything the advancing Allied armies were finding in the spring of 1945. Individual war crimes and systematic atrocity were not different in kind, they were different in scale. The command culture that permitted an officer to shoot a nurse in a Red Cross tent operated by the same logic as the command culture that built Buchenwald. The law applied to both. Germany surrendered on May 8, 1945. The legal machinery began operating at scale. Nuremberg opened in November 1945. The Dachau proceedings, the American-run military tribunal process that would ultimately try hundreds of German officers for specific crimes against Allied personnel, ran from November 1945 through August 1947. The files from Patton's theater of operations, the cases his JAG office had assembled across the autumn and winter of 1944 and the spring of 1945, were among the evidentiary foundations of those proceedings. The case of the German officer who had fired into a Red Cross tent was in those files, complete, documented, with 2 independent witnesses, the chain of command established, the timeline corroborated. But here is where the stakes change in Part 3. because the Dachau trials were not clean. They were contested. German defense attorneys made serious procedural objections that some American legal scholars later acknowledged had merit. Political pressure from multiple directions threatened to overturn convictions. And the specific category of crime, the targeting of medical personnel, became a focal point of that legal battle in ways that nobody had anticipated when Patton first said, "See that the record is complete." The question of whether the file would be enough, whether the documentation would survive the legal challenges being mounted against the entire Dachau process, whether the nurse would finally receive the accounting. Patton had promised that question was about to be answered in a courtroom in southern Germany by lawyers and judges operating under pressures that had nothing to do with what happened in Lorraine in the freezing dark of November 1944. The war was over, but the fight for what it meant was just beginning. The Dachau trials opened in November 1945. By that point, the file assembled by Patton's Judge Advocate General Office contained 47 pages of documented evidence, 2 independent witnesses, a corroborated chain of command, a timeline established to within minutes. It was by the standards of post-war military justice an exceptionally strong case, and it was about to be nearly destroyed. In Part 1, we watched Patton receive the report and issue his quiet directive, make the record complete. In Part 2, we watched him fight the Battle of the Bulge while keeping the case file alive through the operational chaos all the way to Ohrdruf, all the way to Germany's surrender. The file survived. The witness survived. The documentation survived. But here is what nobody told you about the Dachau proceedings. By early 1946, political pressure from Washington and from the newly formed West German government was threatening to overturn convictions wholesale. 41 death sentences from the Malmedy massacre case alone were under review. Defense attorneys were making procedural arguments that American legal scholars were publicly acknowledging had real merit. The entire framework Patton had believed in was cracking under pressure it had never been designed to withstand. And the man who had built that framework was already dead. Patton died on December 21, 1945, 13 days after a traffic accident near Mannheim. He never testified at Dachau. He never saw a single verdict. The institutional champion of the documentation, the man whose specific directive had made the case file what it was gone before the proceedings. That case file was meant to serve had barely begun. The German officer came to trial in the spring of 1946. His defense attorney was a former Wehrmacht legal officer named Friedrich Grimm, who understood the procedural landscape of the Dachau process with precision and was prepared to exploit every weakness in it. Grimm's opening argument was not that his client had not fired the weapon. He did not dispute the basic facts. His argument was procedural, institutional, and in some respects legally sophisticated. That the evidentiary standards under which the case had been assembled did not meet the threshold required for criminal conviction of an individual officer for orders given in a combat context. He argued that the hearsay provisions in the Dachau rules allowed evidence that would have been inadmissible in any American civilian court. He argued that the chain of command documentation was circumstantial at critical links. He argued that the concept of individual criminal responsibility for battlefield orders, however, repugnant those orders had not been sufficiently established in international law at the time the orders were given. These arguments were not frivolous. Some of them were correct. The Dachau proceedings were built on legal foundations that were being constructed simultaneously with the trials themselves, and the construction was imperfect. American lawyers and judges operating within the system knew it was imperfect. The question was whether the imperfection invalidated the enterprise or merely complicated it. Colonel Charles Cheever presented the case for the prosecution. He had maintained the file through the winter of 1944, through the Rhine crossing through Ohrdruf, through Germany's surrender, and through 10 months of post-war legal preparation. He was not a dramatic man. He did not perform in courtrooms. He had been a property lawyer in Ohio before the war, and he brought to the Dachau proceedings the same methodical quality he had brought to assembling the file in the first place. His opening statement lasted 40 minutes. He presented the timeline. He presented the location documentation. He presented the Red Cross markings evidence photographs unit logs, the testimony of the medical officer who had established the site. He presented the first witness. He presented the second witness whose account had been obtained independently and corroborated the first on every material point. And then he presented something Grimm had not anticipated: a third document. In January 1945, during the processing of a separate batch of German prisoners, an intelligence officer had conducted a routine interrogation of a Wehrmacht NCO from the same unit as the defendant. The NCO, not knowing the specific case under investigation, had mentioned in passing that his company commander had ordered the clearing of a medical position in November 1944. He had used the word clearing. The intelligence officer, recognizing the potential significance, had documented the statement fully and forwarded it to the JAG office. It had been sitting in the file for 14 months. Grimm objected to its admission on hearsay grounds. The presiding judge, Colonel Abraham Rosenfeld, overruled the objection after a 40-minute recess. The document was admitted. The German officer testified in his own defense. He was composed. He had clearly prepared extensively. He acknowledged being in command of the unit. He acknowledged the general area of operations on the date in question. He denied giving any order to fire on medical personnel. He offered an alternative account of the events that night, one that placed him at a different position than the witnesses had documented. Cheever's cross-examination lasted 2 days. He did not raise his voice. He did not attempt theatrical moments. He moved through the testimony with the patience of a man who had read the same 47 pages of documentation so many times that he knew exactly where every inconsistency would appear. When the German officer's account placed him at a different position, Cheever produced unit movement logs that documented the officer's position to within a kilometer. When the officer claimed the Red Cross markings had not been visible in the darkness, Cheever produced the testimony of the medical officer who had established the site, who had specifically documented that lamp illumination had been used precisely to ensure visibility of the markings under low-light conditions. The officer's composure began to fragment on the second day. Not dramatically. Not in any way that produced a courtroom moment. It fragmented the way a careful construction fragments when the individual components are removed one by one. A hesitation here, a revised answer there. A moment when the response to a specific question about the timeline did not match the response to the same question asked differently 40 minutes earlier, Cheever noticed. He said nothing. He made a note. He returned to that specific point in his closing argument 3 days later, and he spent 11 minutes on it, methodically demonstrating the inconsistency across 3 separate responses, cross-referenced against the documentary record. The verdict was delivered on April 3, 1946. Guilty. The charge violation of the laws and customs of war, specifically the deliberate killing of protected medical personnel in violation of the Geneva Convention of 1929. The sentence was 15 years imprisonment. It was not death. There were voices inside the prosecution team who believed it should have been. Cheever was not among them. He understood that the sentence reflected the evidentiary complexity of the case, the procedural pressures on the tribunal, the political context in which the Dachau proceedings were operating in the spring of 1946. He had obtained a conviction on the specific charge. The principle had been upheld. The documentation had survived the challenge. He wrote a single sentence in his case notes that day. The record was complete. It was enough. That sentence, written by a property lawyer from Ohio in a courtroom in southern Germany in April 1946, is the culmination of what Patton had set in motion in November 1944. Not with a speech, not with a theatrical gesture, with a quiet directive to see that the record was complete every detail. The Dachau proceedings in total tried 1,672 defendants. 1,416 were convicted. 297 were sentenced to death, of whom 279 were executed. The cases that came from Patton's theater of operations were among the most thoroughly documented in the entire proceeding. The conviction rate in cases with Third Army JAG documentation was significantly higher than in cases assembled with less institutional insistence on completeness. The broader legal legacy is not abstract. The Geneva Conventions were revised and expanded in 1949, 4 separate conventions replacing the 1929 document, with substantially strengthened provisions for the protection of medical personnel. The explicit prohibition on targeting medical personnel was reinforced, clarified, and given additional enforcement mechanisms that drew directly on the evidentiary record of cases like the one Cheever prosecuted. The lesson that the documentation had made the difference, that the accountability machinery only works when someone insists on completeness from the beginning, was embedded in the training doctrine of the International Committee of the Red Cross throughout the post-war period. The nurse whose death had initiated all of this is remembered where she is remembered at all as a case file, a prosecution exhibit, a demonstrated violation of the Geneva Convention. The history does not always preserve her name. This is the failure of the institutional record, which focused on command decisions and legal proceedings and the actions of officers rather than on the individuals whose deaths made those proceedings necessary. What the record does preserve is what she was doing when she died. She was treating a wounded man. She was in a marked medical area, wearing the uniform of the United States Army, performing the duty she had been trained and commissioned to perform. The red cross on her armband was visible in the lamplight. She was killed because an officer decided the law did not apply to him. Patton decided otherwise. Cheever spent 14 months making sure the record was complete enough to prove it. Rosenfeld made sure the third document got admitted. And on April 3, 1946, in a courtroom in Dachau, Germany, a judge read a verdict that said the law applied. It applied that night in November 1944. It applies now. It will apply in every theater where soldiers go and medical personnel follow them into the violence to do the work that the violence makes necessary. The German officer served 11 years of his 15-year sentence. He was released in 1957 under the general amnesty provisions that the West German government had negotiated with the Allied powers. He returned to Germany. The historical record does not follow him further. What became of him in the years after his release, whether he ever articulated what he had understood of the conviction, whether he considered himself to have been held accountable in any meaningful sense, these things are not in the file. The file closes in April 1946, with a verdict, with a sentence, with Cheever's note. The record was complete. It was enough. But here is the question that Part 4 is going to answer, and it is a question that goes beyond this case, beyond Patton, beyond the Dachau proceedings, beyond 1946. It is the question of what actually happened to the principal. Not the verdict, the principle. The idea that a man who fires twice into a Red Cross tent in the darkness of a November morning is not committing an act of war, but a war crime, and that those two things are different, and that the difference matters enough to spend 14 months building a 47-page file to prove it. Because in the 79 years since Cheever wrote that note, that principle has been invoked in Korea, in Vietnam, in Bosnia, in Rwanda, in Iraq, in Syria. Sometimes the record was complete. Sometimes it was not. Sometimes the machinery worked. Sometimes it did not. The story of what Patton actually built, what survived him, what was used, what was abandoned, and what it cost when it was abandoned. That story has one more chapter. And almost nobody knows how it ends. 4 parts. 4 hours of history. And we have arrived at the question that has been sitting underneath everything since the first sentence of Part 1. Not what Patton said, not what the file contained, not what the verdict was. The question is, did it matter? In Part 1, a German officer fired twice into a Red Cross tent, and Patton said, "See that the record is complete." In Part 2, Patton fought the largest German offensive of the Western Front, while keeping the case alive through operational chaos. In Part 3, Colonel Cheever prosecuted the case in a Dachau courtroom, survived a sophisticated legal challenge, and obtained a conviction on April 3, 1946. The German officer received 15 years. The principle was upheld. But here is the twist that closes this story. The one almost nobody knows. It is not about the German officer. It is not about the verdict. It is about what happened to the principle itself in the 79 years after Cheever wrote his note, and what it cost when the people who came after Patton forgot what he had understood. Charles Cheever returned to Ohio in the summer of 1946. He went back to property law. He did not write a memoir. He did not lecture at law schools about the Dachau proceedings. He did not seek recognition for what he had spent 14 months building. His case files were transferred to the National Archives, where they sat in boxes for decades, consulted occasionally by historians and legal scholars, but largely unknown to the general public. He died in 1978. His obituary in the Columbus Dispatch described him as a respected local attorney and Korean War veteran. It did not mention the Dachau trials. It did not mention the 47-page file. It did not mention the nurse. This is the first thing the history teaches if you are willing to hear it. The people who do the quiet, methodical work of accountability are rarely the ones history remembers. Patton is famous. Cheever is a box in the National Archives. The theatrical man with the ivory-handled revolvers has 40 films and 100 books. The property lawyer from Ohio, who spent 14 months making sure the record was complete, has an obituary that got the wrong war. Patton himself, of course, died before he could see any of it. December 21, 1945. A traffic accident near Mannheim. He was buried at the Luxembourg American Cemetery at Ham, surrounded by the graves of men from the Third Army, which was where he had asked to be. The ivory-handled revolvers, the speeches, the slapping incidents, these are what the popular record kept. The other Patton, the one who sat in a cold headquarters and issued a quiet directive about completeness, is less present in the mythology. He is harder to dramatize. He did not produce quotable fury in his serious moments. He produced flat, precise sentences and forwarded them to a JAG officer who understood what to do with them. Major General Harold Bull, the operations officer who had laughed at Patton's 48-hour promise at the Verdun Conference in December 1944, went on to a distinguished post-war career and retired as a 3-star general. He never publicly addressed the moment of laughter. He was not wrong to be skeptical. He was simply wrong about the specific man he was skeptical of. The German officer was released in 1957. 11 years of a 15-year sentence under the amnesty provisions that the West German government had negotiated with the Allied powers throughout the early 1950s. The political pressure that had been threatening the Dachau convictions from their earliest days had eventually produced a systematic reduction of sentences across categories of cases. Some scholars who have studied the period argue that the releases were necessary accommodations to the realities of Cold War politics, that a rearming West Germany needed to be treated as a partner rather than a defeated enemy, and that the continued imprisonment of Wehrmacht officers was incompatible with that political project. Other scholars argue that the releases represented a fundamental failure of the accountability machinery that men like Patton and Cheever had built at considerable effort. Both arguments have merit. That is the uncomfortable historical truth. The legal framework that Patton had pointed toward before it was fully built, that Cheever had used to obtain a conviction that the Dachau proceedings had constructed case by case through 2 years of proceedings, was partially dismantled by the political pressures of the decade that followed. Not entirely. The convictions stood as legal records. The principle was not formally repudiated. But the sentences were reduced, the men were released, and the accounting was incomplete in ways that the documentation alone could not remedy. The Geneva Conventions of 1949 are the permanent legacy. 4 separate conventions substantially expanding and strengthening the 1929 document that the German officer had violated in November 1944. The protections for medical personnel are among the most explicit provisions in those conventions, drawn directly from the evidentiary record of cases prosecuted at Dachau and Nuremberg. The prohibition on targeting protected medical personnel now carries enforcement mechanisms that did not exist when Cheever presented his case. The International Committee of the Red Cross uses the documented history of those prosecutions in its training programs to this day. The specific article, Protecting Medical Personnel, Article 24 of the First Geneva Convention of 1949, was informed by exactly the category of crime that Patton's file documented. The diplomats who drafted it had access to the prosecution records. They knew what the violations had looked like in practice. They knew what evidence was required to prosecute them. They made the language stronger. They made the protections more explicit. They built the lesson of the incomplete 1929 document into the architecture of the 1949 revision. Approximately 196 nations are currently party to the Geneva Conventions. Every military in the world that operates under any claim of lawful conduct does so within a framework that was substantially shaped by what happened in a series of courtrooms in Dachau, Bavaria, between 1945 and 1947. And those courtrooms were shaped by the files that commands like Patton's Third Army assembled in the field under operational pressure, because someone at the top of the command structure believed the rules were not optional and that paper was the instrument of accountability. The lesson about innovation that runs beneath the surface of this story is not the lesson you might expect. Patton was not an innovator in the conventional sense. He did not invent a new weapon or develop a new tactic. What he did was insist in November 1944 on a principle that the international legal community had not yet fully formalized that individual officers were personally criminally responsible for orders that violated the laws of war, regardless of the military context in which those orders were given. He was ahead of the legal machinery by at least a year. He acted on a principle before the statute existed to codify it. This is the pattern that changes wars, and not only wars. The people who are ahead of the institutional machinery, who act on a principle before the institution has formalized it, who insist on completeness when the system has not yet decided what completeness means. These people are rarely celebrated in the moment. They are argued with. They are told the framework doesn't exist yet, that it's legally unprecedented, that there are more pressing concerns, that the operational emergency makes this particular file a lower priority. Patton heard versions of all of these objections. He forwarded the same directive to Cheever anyway. The same pattern appears throughout the history of military and institutional change. The officers who insisted on proper documentation of prisoner treatment before the Geneva Conventions gave them explicit authority to do so. The doctors who insisted on recording adverse medical outcomes before hospital accountability systems existed to require it. The engineers who documented structural failures before regulatory frameworks mandated the documentation. In each case, the institutional machinery eventually caught up. In each case, it caught up faster and more completely, because someone had been building the record before anyone asked them to. The final detail. The one that closes the frame. In 2003, a legal scholar at Georgetown University named Patricia Dillard was researching the Dachau proceedings for a book on the development of international humanitarian law. She was working through the National Archives collection, box by box, and she came across Cheever's case file. All 47 pages. The timeline, the witnesses, the chain of command documentation. The third document, the intelligence interrogation from January 1945, that Grimm had tried to exclude and Rosenfeld had admitted. At the back of the file behind the verdict documentation and Cheever's case notes, she found something she had not expected. A single page handwritten in a different hand from Cheever's. It was dated November 17, 1944, the day after the incident. It was a statement from the first witness written in the field before the JAG office had formally opened its investigation, before anyone had given the order to make the record complete. The witness had written it himself without being asked. He had understood in the immediate aftermath of what he had seen that it needed to be written down. He had found paper. He had documented what he saw, the date, the location, the markings, the German officer, the 2 shots. He had signed it and submitted it through his unit's chain of command. It was in the file because Patton's directive had caused the JAG office to collect everything. But it existed because a soldier on his own initiative on the morning after the worst thing he had ever witnessed had decided that the record needed to be complete before anyone told him it did. Dillard wrote about this page in her book published in 2005. She described it as the document that made the case. Not Cheever's preparation. Not the third document. Not Patton's directive. The handwritten statement from a soldier who had decided on his own in the field, in the freezing November dark of 1944, that what he had seen needed to be written down. The record was complete because multiple people at multiple levels had understood the same thing independently that accountability requires. Evidence, and evidence requires someone willing to produce it before the system asks for it. From a November night in Lorraine to a Georgetown scholar's desk in 2003. From a handwritten page to the Geneva Conventions of 1949 to the legal framework governing armed conflict today. The principal traveled that distance because Patton said, "See that the record is complete," because Cheever spent 14 months making it so, because a soldier on the morning of November 17, 1944, found a piece of paper and wrote down what he saw. The nurse's name may not be in the historical record with the clarity it deserves. The institutional focus on command decisions and legal proceedings reduced her in the documents to a case file number and a demonstrated violation. But she is in the Geneva Conventions. She is in Article 24 of the First Convention of 1949. She is in the training manuals of the International Committee of the Red Cross. She is in every briefing given to every soldier in every army that operates under the laws of war, when they are told that the Red Cross markings mean something, that the protection is real, that someone will be held accountable if it is violated. That is where she is. That is how she was remembered by the people who understood what the record was for. The rules she died under were written because men had decided after the First World War that some things must remain outside the violence. They were strengthened after the Second World War because men had documented what happened when they were violated. They remain law today because the documentation survived, because the principle survived, because someone wrote it down. Remember her. Remember what the law said she was owed. Remember that someone wrote it down. That is the only kind of memory that actually holds,